Welcome, witnesses. Ms. Bodine, are you concerned that the wording of the 2023 rule will create uncertainty for landowners across the West, and particularly in Wyoming?
Yes, Senator Lummis, I am very concerned about that. It has been set up as case-by-case jurisdiction, and as what we've seen before, that has led to regulatory expansion and inconsistencies.
During your time at the EPA, have you ever seen the administration willfully ignore the court's ruling, as they seem to be doing in Sackett?
I have not.
What are they hanging their coat on in terms of departing from what seemed to be clear direction in Sackett to get to where they are today?
In their September 7th or 8th conforming rule, they excise significant nexus out of their regulations. And that is accurate. That reflects what the Sackett decision said. But what they left was all of the interpretive language, which was in guidance in preamble. They didn't put it in regs, and that makes it all case by case, but they left it all intact, and they've said, this is what we're going to do on a case-by-case basis to follow it. And if you compare what they say, how they're going to interpret these terms with the opinion, they don't match. But we may end up having to people may end up having to litigate that on a permit-by-permit basis and not by challenging the rule. That remains to be seen.
It seems so unique to me that this could be dealt with on a case-by-case basis, especially after a decision like Sackett. What makes that possible?
They could have written bright lines in their conforming rule and chose not to. I do think that the agencies are trying to hold on to as much jurisdiction as they had, that they wanted. There has to be some case by case. I'm not going to say that everything is absolutely bright line, but what we have here is essentially 100% case by case.
Yeah, I'm deeply concerned about that because some of the examples pre-Sackett of enforcement actions in Wyoming would, to the just naked eye of people with common sense, seem to be beyond the scope of the federal government. It also seems to fail to recognize state jurisdiction over water, especially quantity, but also quality. So what would you advise if you were involved in the decision-making at the agency as a clarification, so we're not just in this pattern of litigating? It almost seems like an effort is being made to run out the clock on people who are regulated and then have to access the courts to have a more reasonable interpretation of the law.
Yes, most people just want to get their project done, and so they won't litigate. And that is how you get kind of ever-increasing claims of jurisdiction. You talked about some examples that were, older examples of overreach. My concern is that the way they've set this rule up, they've left the door open to go back to that same overreach because of the way they're defining their terms. I would recommend that the operative terms of how the statute should be implemented should be in rule language and not just left to a guidance document.
We're told frequently that guidance is not necessarily something that has to be adhered to with a bright red line. But then there are examples where it is.
Correct.
Does the Congress need to step in and define guidance in a way that makes it less onerous?
If the agencies take the position that a guidance is binding, it's a rule,
Yeah,
and it can be challenged in court.
I thank the witness. Thank you, Mr. Chairman.
Thank you, ma'am. We've been joined by Senator Markey. Senator Markey, welcome. And you're recognized. Before you do that, let me ask for a unanimous consent